Hello, my dearest friends. Svetlana Shlapak, the founder of UKVisaSuccess.com is here. So suppose you are an extended family member and your EEA family permit has been granted, and you may think that this is the end of your journey, whereas in fact this is only at the beginning of your 5-year journey. And in order for you to qualify for your settled status in the UK as an extended family member of an EU citizen, you need to understand the rules and you need to know the circumstances under which you may lose your right to remain here as an extended family member. So in this video, I explain what these rules are. So let us begin.
Guys, but before I explain the circumstances under which extended family members can lose their right to remain here in the UK after their EEA family permit is granted, I would like to remind you that this video is part of the extended family members video series where I explain their rights to enter the UK as extended family members. And I've created this video series because of the deadline. The deadline for submitting these types of applications is on 31st of December 2020. So if after watching this video you believe that someone may qualify to enter the UK as an extended family member, please forward a link to this video because of the deadline, and because they will need to submit the application if they qualify before the deadline at 11 p.m. on 31st of December 2020. If you think you qualify, I strongly suggest that you find my YouTube playlist about the extended family members and you go through the videos. And also just to let you know that if you'd like to know more and if you'd like to know how to submit an application and have a step-by-step guidance with regards to submitting the EEA family permit applications for those who would like to enter the UK as extended family members, you're very welcome to visit this page, ukvisasuccess.com/EFM, where EFM stands for extended family members access, and here you'll find out how you can get access to the online course where I guide you through the entire process of making this application. So when can extended family members lose their right to remain here in the UK? So suppose your EEA family permit application was granted. This is not to be confused with the EU family permit. There are two different types. The EU family permit is granted under the provisions of Appendix EU, and extended family members do not qualify to make an application under the provisions of Appendix EU family permit. They will need to apply under the provisions of the 2016 regulations instead. So suppose your EEA family permit application was granted for 6 months and you are about to travel to the UK. You should be aware that the immigration officer has the power to cancel the family permits at the border, and that is when there was a change of circumstances. So when there is any change of circumstances, the extended family member can either lose their EEA family permits or their right to remain here in the UK, or it may somehow affect their ability to settle in the UK under the provisions of Appendix EU in future. So if anyone resides here in the UK for 5 years and they were granted limited leave to remain, this is any extended family member will need to apply for when they're already in the UK. So when the applications were granted for 5 years, when there was a change of circumstances, or if they do not meet the requirement, unfortunately they will either lose their right to remain here, or they may lose it, or they will not be eligible to apply for settled status after 5 years of residence here in the UK. So the purpose of this video is just to explain what these circumstances are, just to make you aware what not to do when you're already in the UK. So these changes of circumstances may affect either the EU national, or you as an extended family member, or they may affect both categories, the EU nationals and you as well. So here, let us first of all talk about your EU national relatives who are already in the UK, and hopefully they already have their settled or pre-settled status under the EU settlement scheme. So what may happen which may affect your application? You need to remember that if your family permit application was granted because of you being an extended family member, you need to remember that your rights will be closely tied to the rights of the EU national. So if someone is traveling to the UK, at the border they may ask you questions about your EU national relative, and these questions will be directed at establishing whether or not this EU national family member is exercising treaty rights, in other words, that he is a qualified person. So we've discussed this in more detail in a previous video, so you're very welcome to explore the playlist which is called Extended Family Members to watch these videos. But in very simple terms, a qualified person, a person who is exercising treaty rights, is someone who is either a worker, a self-employed person, self-sufficient provided they have a comprehensive sickness insurance, or a job seeker. Job seekers can be in the UK looking for a job for up to 91 days without losing their qualified person status. So they may ask you at the border if your EU national relative is still a qualified person, and this is really important for you to ensure that they are when you cross the border. However, just to draw your attention here that after you entered the UK and you applied under the EU settlement scheme for your pre-settled status, it's no longer a requirement for the EU national to qualify their treaty rights. So once you are here with the pre-settled status, it doesn't really matter if the EU national is working, self-employed, self-sufficient, or a job seeker. All they need to do is they need to establish that they continue meeting the requirements for you as their relative, and secondly, that they are residing in the UK. But this is after your pre-settled application under the EU settlement scheme was granted. And the second thing which may happen with you and your EU national relative is when they decide to discontinue their support of your application, when they say that they no longer want to be the sponsor in your application, and or they don't want to reside, or they want to leave the UK. So in these circumstances, unfortunately, in many circumstances, you will lose your right to remain here in the UK as an extended family member. However, there are some very tiny exceptions to the rule. Okay, so these were two main changes of circumstances which may affect your right to remain here in the UK. Let us talk about you as a visa national. So especially if you are a visa national, you need to remain here in the UK with the right which is confirmed by the Home Office. So this right, first of all, was confirmed by the way of granting your EEA family permit application, and once you're in the UK, you'd need to apply under the EU settlement scheme for your pre-settled status in order to have your further right to remain here, which will be granted if the application is successful for 5 years. So what may happen which may cause you losing your right to remain here in the UK? Generally, this is where you no longer meet the qualifying conditions, and I did explain these qualifying conditions in more detail in my previous video, so you're very welcome to watch this video. But here I will give a very brief summary of what these qualifying conditions are. There are 4 types of extended family members. The first one is when you were either financially dependent on your EU national relative, or you were a member of the same household when you were living outside the UK and you continue with the same arrangement here. So you either are financially dependent on your EU national relative or you reside in the same household. This is a mix and match requirement. So this means that if, for example, you were residing in the UK outside the UK in the same house, you can enter the UK and you can live separately, but you may still be dependent financially on your EU national relative. So this is really important for you if you were granted if your EA family permit application was granted in this category. This is incredibly important for you to continue meeting these requirements for the entire duration of your pre-settled status grant. For the next 5 years, you will be tied closely to your EU national relative, and you will need to make sure that you either continue residing together or you are fully or wholly financially dependent on your EU national relative. And this has to be a continued support. So you need to either live together for the entire duration of your pre-settled status, or you need to be fully or wholly financially dependent. So if you are relying on the financial dependency and you start working, unfortunately, you may lose your right to remain here as an extended family member because you are no longer residing together. However, you may resolve this issue by becoming a member of the same household. As I said, this is a mix and match requirement. So if you would like to start working, then you'll need to ensure that you become a member of the same household for the entire duration. So there should not be any gaps either in your financial dependency or you living together. So if you don't meet these requirements, you may lose your right to remain here as an extended family member. So this was our category, which is described at Regulation 8.2. The second category is where we had the extended family a member who was reliant on the EU national or their spouse because of the serious health grounds, which was significantly beyond ordinary ill health. And they required personal care, which must be provided on the day-to-day basis. So what may happen here, which may trigger the loss of your status as an extended family member, is when you recovered or the EU national or their spouse can no longer look after you. So if this happens, unfortunately, you may lose your right to remain here as an extended family member. So this is really important for you to ensure that this condition is there for the entire period of your pre-settled status, for the entire period. So once you are here and you applied for your pre-settled status and it was granted, you will need to ensure that you continue meeting the same condition for the entire period of this grant. The third category is when your application was granted because you meet the same requirements which are for the adult dependent relatives. And in previous videos, we already established that this is an incredibly high threshold cases where the person is so disabled that they are not only able to look after themselves, but the EU national sponsor was either unable to find someone in their country of origin who would be able to do this for them, or it was so expensive that they could simply no longer afford this. If your EA family permit application was granted under this category, under the category of Regulation 8.4, you'll need to ensure that you continue meeting the same requirements for the entire duration of your pre-settled status. And the last category is for the partners in durable relationship. Guys, this is only granted normally after 2 years of cohabitation. And if your EA family permit application was granted for 6 months, all you need to do is you need to ensure that you continue residing together as partners in durable relationship. I would like to draw your attention here that unfortunately, if there was a breakdown in your relationship, unfortunately, you will not be able to be entitled to any rights as a partner in durable relationship. So if you'd like to secure your rights to which the spouses are entitled, you'll need to get married, because under certain circumstances, the spouses of EU nationals may retain their right of residence in the UK despite the fact that there was a marriage breakdown. So if you'd like to secure these rights, you need to get married. And I did mention that there are some other circumstances which actually relate to the EU national and the extended family member. And there are 3 categories. First of all, where there are some issues connected with the deportation, exclusion, or criminality, when there was a dishonesty in the application, and when the family member has breached the continuity of their residence in the UK. So let us consider them by chance. So first of all, in accordance with the Appendix EU 15, the application will be refused, and we are talking about either the pre-settled or settled status applications if there was a deportation or exclusion order or a decision to exclude the person from the country. So if there was a deportation order either for the EU national or their extended family member, unfortunately the application will be refused. So this is the first one, and I would like to draw your attention here that if the person had a criminal conviction of over 12 months, then they will be recommended for automatic deportation. So you have to be very careful, and you need to make sure that you have an immaculate immigration history here in the UK, and of course you do not breach the law in any way or form. And then we also have the rule which is outlined at paragraph EU 16 of the Appendix EU, where they say that the application will be refused and may be refused if the decision maker can prove that it is proportionate, where in relation to the application and whether or not with the applicant's knowledge false or misleading information, representations or documents have been submitted. This bit about whether or not with the applicant's knowledge is very important, because sometimes the false documents or information can be provided by the third party, and even if the applicant was not aware that this was false information, and if the Home Office finds out about this during the consideration process, unfortunately the application will be refused, even though the applicant can still prove that he didn't or she didn't know about the fact that the documents were false. So it's really important for you to ensure that you are not providing any false or misleading information or making any representations which are false or misleading. Also, where the applicant is subject to removal decision, then unfortunately this may trigger the refusal of your application. So that was the dishonesty bit. And also you should be this one is really, really important, because I came across many applicants, many EU nationals and their family members, when they don't actually know that they can breach the continuity of their residence here in the UK. So they think that if their pre-settled status application was granted for 5 years, they can be outside, and then they will be perfectly entitled to their settled status after 5 years. This is not so. You'll need to make sure that you meet the continuous qualifying periods. So let me explain the rules. Here they say that first of all, your residence will need to have begun in the UK before the specified date, and according to the definition of Appendix EU, the specified date is 31st of December 2020, so the residence will need to have begun before 31st of December 2020, and there were no absences from the UK for more than 6 months in any 12 months period of time. And they give 3 exceptions here. First of all, they will be willing to exercise their discretion if a person was absent from the UK for more than 6 months only once, so they only allow one single period, which doesn't exceed more than 12 months. So where the absences were between 6 months and 12 months for important reasons such as pregnancy, childbirth, serious illness, study, vocational training, or an overseas posting. Needless to say that if you are relying on this exception, you will need to provide really strong evidence confirming that this exception applies. And also they say that if you were absent from the UK because of the compulsory military service, any periods will be disregarded. So in theory, if you entered the UK, you were granted your pre-settled status application was granted for 5 years, and then you were absent from the UK for, let's say, 4 years because of the compulsory military service, you will still be eligible to get your indefinite leave to remain under the Appendix EU. The next one is any period of absence because of the posting on ground service, and also any period which you spent working in the UK marine area. And they say that you will break the continuity of your residence in the UK if you start serving a sentence of imprisonment of any length in the UK, or if there was a decision or an order to exclude or remove you from the UK. So irrespective of your absences, so even if your sentence of imprisonment was for 2 months, this means that you will break the continuity of your residence. So I can't emphasize enough the importance of you being a law-abiding citizens without any criminal convictions. And these were the rules and the circumstances which may affect your ability to remain in the UK as an extended family members. Guys, please make sure that you follow the rules, and after your arrival in the UK with the EEA family permit, you make your application for a pre-settled status, and you make sure that you meet the qualifying conditions and the EU national is still here in the UK, and you meet all other requirements, and you in this way, because if you do so, you are highly likely to meet the requirements for the settled status in the UK. I would like to invite you to visit this page, ukvisasuccess.com/more, where you'll find plenty of free immigration resources explaining various immigration rules. And I also invite you to subscribe to a new, very, very succinct and short newsletter where I'll be updating you on various changes in the world of UK immigration law, and also I will be sending various exclusive invitations to the members of ukvisasuccess.com community. You'll only be able to get these offers if you are subscribed to this newsletter. Have an amazing week, guys.